We have, like I said, three amazing guests with us today, and hopefully we'll shed some light on the VJRA and the beginnings of the court. First, Bill Brew served as a staff member on the Senate Committee on Veterans Affairs for more than 25 years. He held various positions, including Chief Counsel and Staff Director. He also served as the Director of Intergovernmental Affairs for the Alliance of Aging Research, a counselor to the President's Task Force to improve health care delivery for our nation's veterans, and an analyst and senior staff member of the CARES Commission. He is a 1967 Naval ROTC graduate of the University of Notre Dame, after which he served 6 years in the U.S. Navy, and is a 1976 graduate of the Columbus School of Law at Catholic University. He's the father of 5 children and native of Northern Virginia. Patrick Ryan served as a staff member on the House of Representatives Committee on Veterans Affairs for 21 years, including serving as its staff director and chief counsel from 2001 to 2004. He previously served as a staff attorney in the VA Office of General Counsel, a budget analyst in the Office of Management, and a benefits counselor in the Washington VA Regional Office. He now works as a consultant. He earned his undergraduate degree in government and politics from the University of Maryland and his law degree from Georgetown University Law Center. And finally, Barton Stichman is the Joint Executive Director of the National Veterans Legal Services Program, a nonprofit veteran service organization that was just founded in 1980. Over the last 42 years, he has represented current and former military personnel before this court, as well as other U.S. district and appellate courts, and before both VA and Department of Defense boards. His litigation efforts have resulted in payments of more than $4 billion in benefits to more than 100,000 veterans and their families. In addition, he has trained thousands of attorneys and advocates, helped organize 2 national pro bono programs, including the Veterans Consortium and Lawyers Serving Warriors, and is the co-author or author of multiple articles and books, including NVLSP's Veterans Benefits Manual, which, the law clerks here, I don't have to tell you what that is. He earned his law degree from New York University and an LLM from Georgetown. And finally, welcome, sir. I'll turn it over to today's moderator, who needs no introduction, Judge Mary Schultz.
Thanks, John, and we'd like to thank the Historical Society for hosting this, what we hope will be an interesting panel. And I'd like to thank the panel in advance. In the interest of full disclosure, Bill Brew was my boss for part of the time I worked in the Senate Veterans Affairs Committee. Bart Stichman was technically my boss when I was a law student intern at NVLSP. I never worked for Pat. But I did work with him and occasionally spar with him. So now's my opportunity to turn the tables on all of them and ask them some questions. I hope you've all had the opportunity to read Bill Brew's remarks from the court's 20th anniversary ceremonial session. A link is on the latest email from the Courts Bar Association reminding you of the event if you want to go back and get it later. I'm going to start with a couple of questions and get us started, but then we want to hear what it is that you're interested in hearing about. So please start thinking of your questions now for our panelists. And for those of you watching online, you can please send your questions to history@uscourts.cavc.gov. And that's what this laptop's all about. I'm going to try and play like radio producer and pull up questions as we're going, so bear with me. But we'd love to hear from all of you, and we'll get to as many as we can. First, gentlemen, can you each in turn please describe your roles in drafting the judicial review bills and your involvement in their ultimate passage? Let's start with Bart.
Well, I was working with NVLSP and Vietnam Veterans of America for the 10-year period that this battle for judicial review took place, and it was really one of the most rewarding and important experiences of my legal career, resulting in the landmark legislation. And it was really a David versus Goliath battle. You had relatively small organizations, Vietnam Veterans of America and our organization, aligned against what was called the Iron Triangle, which is the VA, the House Veterans Affairs Committee, the Senate Committee came on late in the game, and the major veteran service organizations. And it was a long battle. At least we had the Senate and Senator Cranston on our side in that battle. a lot of twists and turns, but the one thing I'd like to point out is that I've heard over the last 25 years some revisionist history. Some people who say that the veteran service organizations, the major ones, ended up supporting judicial review. As I think Justice Scalia famously said in one opinion, don't believe them. It's not true. I have a book here. This is the hearings that occurred before the Senate, maybe 4 months before passage of the Veterans Judicial Review Act. And all the organizations testified, those 3 organizations, Disabled American Veterans, the American Legion, and the Veterans of Foreign Wars, as they had in all previous testimony from 78 to 88 against judicial review. So it was quite a battle, and I'm glad to have been part of it.
Pat, please.
So I'm going to disclose a few things that I have not previously disclosed. And I will tell you that my initial involvement with judicial review actually began while I was working as a budget analyst in the Department of Veterans Affairs. And I was going to law school at night, and I was taking a legislative drafting class. And one of the requirements of the class was that you had to produce a piece of legislation. So I took as my topic creating judicial review of VA benefits decisions in the district courts, and I still have a copy of that bill someplace. Fast forward to 83, I joined the staff of the Committee on Veterans Affairs. Mac Fleming was the chief counsel at the time. Sonny Montgomery was the chairman of the committee. He was not the senior member of the committee, however. Senior member of the committee was a fellow from California named Don Edwards. And Mr. Edwards, for whatever reason, elected not to take the gavel of the committee, and so Sonny became the chairman. Fast forward to 86, the committee had 4 days of hearings on legislation, which all of the major veterans organizations, except for VVA, testified in opposition to the bill that was under consideration. Mr. Edwards asked Mr. Montgomery to hold those hearings. He then asked him to hold a markup of the bill, which means that the committee would either favorably or unfavorably report it. And Mr. Montgomery, because he was the kind of person he was, he said, well, I feel I have to give Don Edwards a vote. And he did give him a vote of sorts, but what happened in the end was that Mr. Montgomery worked with a handful of Democrats and all the Republicans who effectively tabled the legislation in 86. In 1988, in 1987 and 1988, the committee did not have hearings on the bill, or any bill, dealing with judicial review. But I think it was probably May of 1988 that I got the signal from Mr. Fleming and Mr. Montgomery that we were going to produce a bill and that nobody was going to know about it. We were going to introduce the bill after Labor Day and basically give the Senate very scant time to consider what it is that we had prepared. So from May to September, October of that year, I pretty much spent all of my time drafting a bill and drafting a report. I got some assistance from John Brizzi, but it was interesting. Normally, we relied on the Legislative Council to guide our drafting. But our Legislative Council at that time, a guy named Bob Cover, was wrapped up in the Armed Services Authorization Bill and said, Pat, I just don't have the time. Why don't you go ahead and take a stab at it? And we did eventually pass that bill, and the rest is, they say, it's pretty well written and out in history.
For those of you who don't know, Legislative Council is a nonpartisan staff. The House has one and the Senate has their own staff, and they make bills look like bill language, the whereases and all that kind of thing. And so they support the members and the committee staff in drafting bills.
Thank you.
Bill.
I start by thinking that we're talking about nearly 30 years ago, and since I can't accurately remember what I did 30 days ago. Please take everything that follows with more than a little bit of salt. Also want to start with that wonderful old bit of philosophy about the blind men and in a room with the elephant, and they each are allowed to feel a piece of the elephant and then describe what it was. The takeaway from that for me is always that, what you see depends on where you sit. So where I sat is in the Senate, and judicial review was mine from the first day I walked in, which was in April of 1978. If you've seen the remarks that I made at the 20th anniversary, I'll just do it quickly, just to set the stage how it was that in '78 I walked into it. In 1976, as the Congress was winding down, Gary Hart of Colorado had a very short, I think it was a 5 or 6 line bill to repeal the preclusion of judicial review and to repeal the limit on attorney's fees. And he brought it to the floor as an amendment. He was going to offer this an amendment to a major piece of veterans legislation that was then being debated, having to do with the GI Bill, the education program, which had been woefully underfunded, still was. I went to law school in the GI Bill, and it didn't pay a lot of the bills. But he, let the floor manager, who at the time was the chairman of the Senate committee, Senator Hartke of Indiana, know that he was going to offer this amendment. And the bill itself, the underlying GI Bill, was going to be contentious enough that Senator Hartke implored him to not offer the amendment. And in what he offered in return was, he said, I'll hold hearings on your legislation in the next Congress. And so with that assurance, Senator Hart pulled down the amendment, and the GI Bill amendments were done, so forth. The problem with the promise was that Senator Hartke returned to Indiana and promptly lost. So that when Senator Hart came around with this little promise from Senator Hartke for hearings, there wasn't anybody there to answer. Senator Cranston of California had become the new chair, and he agreed to hold hearings, and he proceeded to hold 5 days of hearings, 2 here and 3 around the country, on the concept of judicial review. And that took from the start of the Congress in '77 through to, my memory is probably late in that first session. So as I said, I arrived in April of '78, the second session of that Congress. And on my very first day, after finding out where the bathroom was and whatnot, I went into my boss and I said, okay, what's my assignment? And sitting on the corner of his desk was a pile of paper this thick. And that was what are called galley proofs. I mean, this is all, it's all way back in the day stuff. This was the way hearings were printed. And the galley proofs were in, and I was handed the galley proofs, and I was told to get busy and to start working on judicial review. The only thing I remember from that day, of course, as I said, it was the first day, so I was trying to appear to be, very much on top of my brand new job. I said, so what are we talking about, an Article 1 court or an Article 3 court? And the general counsel looked at me and said, good question. As to follow Pat's model, fast forwarding, what we decided on was to provide for review in Article 3 courts. And the Senate committee reported, and the Senate passed a substantial judicial review bill in each of the next 5 Congresses. And in each of those Congresses, when we would meet with our House counterparts to talk about working out the legislation for that session, we'd say judicial review, and they'd say, nope. And that was it. and there really wasn't much to be done about that. I mean, there wasn't leverage. There wasn't a way. Pat mentioned Don Edwards, who was a very extraordinary fellow from California. He and Senator Cranston were very close, and he was the biggest advocate in the House for judicial review. And I believe the reason he didn't take the chair was because he had a senior position on judiciary that he didn't want to give up.
Right.
But he had no leverage either. There was no place to put the pointy end of the crowbar to move things. And just to back up a half a step, because people will frequently say, "What, 10 years, 5 Congresses? I mean, don't you get tired? Isn't that futile?" When I arrived in '78, it was actually the next year that the Congress enacted legislation which created readjustment counseling in VA, which is what's carried out through the vet centers. That had taken 10 years. Senator Cranston had introduced it in his first year in 1969, and it took until 1979. So waiting 10 years was no big deal. It was just sort of the way the process went. But anyway, as I said, fast forwarding. Pat accurately described what I gather accurately described what they were doing. I will tell you that we had, that is those of us in the Senate, no clue. None. Zero. In Congress, of course, is a 2-year period. In the second session of a Congress, there is a day when the Congress adjourns sine die, which means without day for reconvening. That's the end of the Congress. You don't know when sine die is. It's in the hands of the leadership, but you never know when it is. You know if it's an election year, it's going to be a little, so which of course the even number years always are, and that was a presidential election year, '88. You know it's going to be sooner rather than later, but you don't know when it is. So it's that old, and I'm now going to make a really, really back in the day reference to a show when I was a child that was on TV called Beat the Clock. I'm sure there's nobody who remembers it, but it involved setting a big clock, and you had to accomplish something before it was done. We were basically playing Beat the Clock if we were going to get something accomplished between when the House acted and when sine die arrived, which was not a known date, okay? So backing back up, I get the word that the House is going to put forward a bill. And Patrick didn't describe the bill, but I will. It abolished the Board of Veterans' Appeals and created a 65-member court. I will tell you, when I read the bill, I laughed. I said, that's the stupidest thing I've ever seen. We're not going to get anything done this Congress. Game over. Unfortunately, Congressman Edwards called Senator Cranston, said, look, Sonny's doing something. For God's sakes, work with him. Senator Cranston calls me. Bill, call Don Edwards. Pardon me? So he called Don Edwards. Well, of course, I didn't call Congressman Edwards, but I called his staffer with whom I'd been working. I said, what's going on? He said, the congressman wants to try and get something done. The first day I heard the word judicial review and House was September the 20th. And I actually do know this because I keep a diary. Sine die was October the 20th. In 1 month, we took a bill that the Senate had passed multiple years that provided for review in Article III courts, and a bill that the House had passed. It created a 65-member court.
Sounds amazing.
And in that period of time, we managed to cobble together a piece of legislation. And I'll tell you last thought, and then I'll stop. Had we been creating a program in VA in that time frame, brand new program, even if we had gotten it done as we got judicial review done, it would have been a hopelessly bad program because we wouldn't have been able to have thought it through. We wouldn't have had the opportunity to get it reviewed. We wouldn't have had the opportunity to smooth it out. Because we were creating a court, And basically all we were doing was taking the champagne bottle and breaking it on the bow and pushing the court down the waves. It was then the courts to do. And I will say to you, and I mean this in absolute all sincerity, and this is not, I don't want to be suggesting that as a Hill staffer that always had a warm and fuzzy relationship with the first Chief Judge. But those of you know who Chief Judge Nebeker, he did it. He took this make a court, and by damn, he did it. And then the court, and I will then say, in terms of my involvement going forward, because I was still on the Hill for many years after that, my biggest involvement with the court going forward was to try and keep others, and this is not the House, this is, you'll be able to sort out, I'm talking about the Senate Republicans, from messing with the court, instead of just letting the court be the court. That was our view was, we created a court, and it was to the court to go forward. And that's, of course, assumption. Anyway, that's the long-winded, there you go.
Well, that's what we're here for. So you both alluded to this effort was out in the desert for years searching for a way in, and then finally in 1988, something was different. And Pat, can you give any more highlight or illumination as to what changed, what broke the logjam?
Well, I will say that after the hearings in 1986 and the markup, there was still a lot of bad feelings on both sides about what was going on. And I can just remember beginning, Rick Heilman was the legislative guide for the disabled American veterans. And Rick would come up regularly and we'd just, chew the fat, talk about various topics. And as I recall it, Rick told Mac and me and Sonny that the DAB didn't want to continue to have this fight in public, that it was not helpful to them, that if there was a solution, that maybe they could change their position. It turns out, as those of you who looked at the long history of this, the House actually recorded a bill in 1962 that created a 65 or 50 member court, independent court. And Rick knew about that, and I think his boss did. And so I can distinctly recall having conversations, perhaps more in 1988 than in 1987, with Rick, and there was a junior vice commander named Joe Zengel, who seemed quite enamored of this topic. And having sat down with them and talking about, well, could you live with an Article I court? And the answer was, yes, we think we can. It was something that, having spent a fair amount of time looking at the effects that an Article III court might have on, the opinions coming up in different circuits, interpreting the law in different ways. It seemed to me that was a logical thing. In terms of what actually came out of the House in September of that year, I will tell you that Mac and I argued a lot about that. I didn't like this idea at all, and my proposal to him was more or less on the tax court legislation. But Mac had something he wanted to stick it to somebody, is my take on it. And he got Sonny to agree with him that it was a good idea to put a bill out that just had no chance of being accepted by the Senate. I think that was his strategy, his thought process all along. And I think he was frankly surprised that we got to where we got to in a month's time. But it was, I think there was some logic behind it. There was a chance to put this behind us. And although the major veterans organizations never came out publicly in favor of the Article I court, we had their connivance, I would say, or their agreement that it wouldn't be such a bad thing.
Well, great. Now that we've established where we got to, I'd like to open it up to questions from the audience. And again, for those of you out on WebEx, you can send your questions to history@uscourts.cavc.gov. Anybody have a question? Otherwise, we'll go back to my canned, boring ones. Judge Bartley.
I'd like to hear more about the reasons why the service organizations were against any of the legislative proposals, and is it just something as obvious as afraid of some of the power being taken away, or were there other factors?
I'll give a quick answer, and then you two can jump in. Certainly, the disabled American veterans had a big stake in providing free advice to veterans who were filing claims with the VA. I will tell you that I went back and found hearings where major veterans organizations testified in favor of judicial review. But over the 60s and 70s, I would say what happened was that the powers that be in the major organizations saw this as a challenge to them, that they weren't doing the job that they were supposed to be doing. Whereas I think VBA had no such idea that it was going to adversely affect them. I think the VSOs thought it was going to have an adverse effect on them. Bill, take.
Well, this plays off of what I said at the start about it depends on where you sit. I'm sure Bart's reflecting accurately what was said on the record. What I can tell you is I couldn't have gotten it out of the Senate 5 times if the veterans organizations were dead set against it. I had the VFW quietly, the American Legion leaning. PVA was solidly with us, but never in a public way. My biggest impediment through the years was DAV, and it was about attorneys. It was about they didn't want. They felt that if we created a court, then attorneys followed, and attorneys following was something. I mean, they were. It was incredibly strong view anti-attorney. But no, I think what Pat said, and remember the other thing, what doesn't get discussed much, we fought the administration, the Veterans Administration, tooth and nail the entire time. They never, ever came around because they were always of the view that judicial review suggested that they weren't doing the job. And so,
but Bill, wait, when you were working on your bill, Guy McMichael had Dean Phillips in that task force.
Dean was inside, but I'm going to tell you again where you sit. Guy was very clear that they were never going to let it. I mean, he said, Guy said, it could come out of the Senate.
Oh.
It wasn't that they were fighting us that, the Senate can't pass it. And that's the other thing, the reference to the Iron Triangle. The Iron Triangle was always the organizations, the VA, and the Congress, but the Congress was the House committee. The Senate committee, the Senate Veterans Affairs Committee, didn't come into existence until 1971. Veterans things were divided among other committees before 71. And I think that it is fair to say that the Senate committee was perceived as being more sympathetic and more aligned to the younger veterans. Senator Cranston was elected in '68 based on a very, very strong anti-war stand and came to Washington and was put in charge of a subcommittee on Veterans Affairs. I mean, it was one of those just wonderful ironies. And I will say to you, and let me come back to that because I meant to say it earlier. And this is a sort of a back in the day and a bemoaning the current state of affairs. Alan Cranston was one of he was of a class, of a group of people who saw public service as a worthy lifetime commitment. Alan Cranston was about being a legislator, and his stance was always get what you can get and live to fight another day. Don't walk away. And that's why, in fact, we negotiated. When I told him we weren't going to negotiate, he said, "Oh, yeah, you are." You know, go get what you can get. I said, Senator, the Congress is ending. He said, work until it ends. Yes, Senator. And we did, and that's how we got. I mean, no, I truly.
And the history of the House Veterans Committee would suggest that people sought the chair, the gavel, sought to become the chairman, who were from the South. At least Mr. Montgomery was from Mississippi.
Mr. Roberts
from Texas.
Mr.
William Giants Dorn was from South Carolina. So it was more acceptable in the House to be the chair of the Veterans Committee if you came from a somewhat conservative background. Thus, Don Edwards, who could have been the chair, elected not to be the chair because it wasn't his thing. And, you know, it's an unusual way of, 74 changed the Hill forever, 96 changed, or 94 changed it too. But the people who were elected congressmen began to change in 1974, I think, and we began to see members of the committee, at least Democratic members of the committee, who were more reflective of the views of metropolitan areas. I'm thinking of, you know, Bob Edgar, for instance. Right. And the other thing I would say is we had this history of working on a bipartisan basis, and the Republican members were even more as conservative as Mr. Montgomery, if not more so.
Well, and Pat mentioned earlier the vote in '86 and Mr. Montgomery. Mr. Montgomery, I make it literal, but he had a backdoor pass to the Reagan White House. I mean, he was, and well, much more than that. The first President Bush was allegedly the only person on the planet other than his mother who referred to Sonny Montgomery by his given name. I mean, nobody. Gillespie. Yeah, and President Bush called him Gillespie. But he was he was a blue dog Democrat. He was very clearly a very conservative Democrat. But also, and again, I started in '78. I remember the first time we had a meeting with the House to negotiate some legislation. And sitting across the table from me were 3 World War II veterans. And they were quite happy to dismiss me as having no knowledge about nothing and to just be quiet, please. I mean, it was that kind of a difference. So
let's look back around. Bart, did you have anything to add to Judge Bartley's question?
Yes, I think part of the opposition was veterans from previous wars versus Vietnam veterans. The Vietnam veterans felt they weren't getting a fair shake at the VA in benefit claims. The VA didn't believe in post-traumatic stress disorder. It didn't believe in exposure to Agent Orange causing anything. And so they looked at the court as judicial review as somewhat of a panacea for those problems that they couldn't resolve at the VA. And that was reflected in the composition of the major veterans organizations. They were controlled by the World War II vets and Korean War vets. So that was part of it. And then certainly the turf battle with the veterans organizations providing the sole source of representation and the fear that lawyers would intrude on that turf. I remember the NARS case, National Association of Radiation Survivors, challenge to the $10 fee limitation, which went to the Supreme Court. The DAV filed a friend of the court brief against the plaintiffs, fearing, they said, that if judicial review was created and the bar to $10 attorney's fees lifted, that veterans, law firms would hire away all their non-lawyer service organizations as representatives as paralegals, and it would destroy their representation system.
You mentioned NARS, and I think something else that was always talked about, and having worked inside the VA a little bit, I could see where this maybe was and wasn't being faithfully implemented. But the notion that the VA was supposed to give the benefit of the doubt to the veteran, that notion, people believed it would no longer be true if the VA had an adversary at every step of the process. And I think that, in fact, some of those lawsuits you're talking about, a couple of other ones, exacerbated the fear that lawyers were going to just take over the VA.
Okay, any other questions from the audience? Come on, people, I know you got stuff. Judge Davis.
Could the panel shed some light on what happened, what transpired in the 1 month? It went from the 65-member Article 3 court to the 7-member Article 1 court. What happened?
I think that's where the 30-year gap comes into play. I think as best I can reconstruct it, with the notion that we were that we actually were going to negotiate, my memory is we gave on the Article 1 right away, but said not 65. And then we went from there.
And I never believed that 65 was the right number.
And let me I want to make this real clear so that for the record, and we've talked about it in the past, but it's when we went into those negotiations, Patrick led them. I didn't know what an Article 1 court was. Pat had been studying them and paying attention and had models and had a sense of what made up such an entity. So we started with that. And
the other thing, in between the time the bill was introduced and the House committee actually took it up, Don Edwards pitched a fit, of course, and in fact threatened to hold up consideration of the bill on the floor by having the bill referred to the Judiciary Committee. In fact, it was referred to the Judiciary Committee for a couple of days, and I guess that his objections to the creation of the 65-member court maybe woke Mac up or something. But, I mean, I've been telling him all along it didn't make sense to me. And so I think, again, going back, despite the fact that Sonny and Don Edwards were at complete opposite ends of the political spectrum, they were both gentlemen, if I can use that phrase, in the sense that they were agreeable kinds of people. And so they had conversations, which I was not a party to, but certainly their conversations influenced back. And because we had this, I started with this model, it was not hard for me to kind of point out where we could land up.
But it was not just a 65-member court. It was getting rid of the Board of Veterans.
Oh, believe me, my phone was ringing off the hook on that one. I mean, they were calling me at home on that one.
Okay, anybody else?
I'm curious about the decision about pathways of appeal. So, for example, why have the appeal to a federal circuit rather than appeal decisions from this court going straight to the U.S. district courts for re-adjudication on the facts, fact-finding, that sort of thing, from that basis? And talk about the method of siphoning off the decision and achieving more finality.
That was the fact legal issue dichotomy that isn't really a dichotomy was certainly one of the things that the disabled American veterans talked to us about. The idea that you could have basically relitigate the entire case before a federal district court was not something they thought was a good idea, and I tended to agree with them on a personal basis. But talking about the Court of Appeals for the Federal Circuit, that was one where we just weren't sure. And I want to echo what Bill said earlier about, just the fabulous job that the first three judges of this court did in taking a pretty blank tablet and turning it into something that is really, I think, at least I hope they're proud of the work that they did, because it is, I think it's working really well. And I think, frankly, there's very little legal reasoning behind the pathway of appeal. It was, we just weren't sure, and we weren't sure that decisions of the court would withstand scrutiny if they went straight to the Supreme Court.
And again, and this is not to make too much of it, but in all of my years, I never was involved with creating a piece of legislation on basically a blank piece of paper in 30 days. That's not how legislation is done. You know, when you do the schoolhouse rock and I want to be an act, it's a long and drawn out process, and it should have been. It should have been. I really and truly, it would not have been, but I think for the confluence of Mr. Montgomery, Mr. Edwards, and Senator Cranston, each, and when you said they were gentlemen, what I would say is they were savvy politicians who were about getting the job done, and in fact, I think that was, you know, it all came, and as you said, I mean, it was Congressman Edwards talking to Chairman Montgomery, you know, head to head. But 30 days is not, well, in fact, at one point I copied this out. The legislative history, the bill number was S11, and the legislative history for S11 in the Senate, I don't know, runs to some 30 items. The House bill runs to about 10, and 3 or 4 of them are laid on the table and picked up and passed. I mean, the legislative history, such as it is really not the sort of, that's not the way to make sausage, but we did it.
Well, one of the things that we discussed in our phone call preparing for this, Pat mentioned that there were concerns about the reason for inserting the Federal Circuit was also concerns for the amount of expertise that would come to the court in the original judges. And so could you kind of pick up on that a little bit?
Well, again, it was just the uncertainty at the time, not, you know, we had the Court of Military appeals from that go directly to the Supreme Court. But again, the tradition there is that you've gone through a full military trial before it goes to the Court of Military Appeals. And I wouldn't say that the Board of Veterans Appeals at that time was the equivalent of a full military trial by any stretch of the imagination. So it was the question, well, if they really get it wrong right out of the box, is there some way to avoid having the public embarrassment of the Supreme Court going, oh, you got to be kidding me. So it was, but again, there was the theory that it should be unitary, that there should not be 12 circuit courts looking at the decisions of this court. And
Pat also told me he didn't think that we need that anymore.
I certainly don't think that over the years, the few decisions that I've managed to read, I don't think added very much to the
from the Federal Circuit
clarity of the decisions coming out of this court.
Let me just add about the Federal Circuit. I know that Vietnam Veterans of America and our organization were fearful about specialized courts, and one of the major reasons is it's a clean slate, and who knows who the president is going to appoint as far as judges are concerned. If it weren't prominent people who would be good jurists, then judicial review, let's say they worked at the VA for 20, 30 years. Well, some of them actually were appointed that way. But, no, if it wasn't serious people like ultimately President Bush nominated, we wouldn't have won the battle that we had fought for 10 years. And so the existence of the Federal Circuit was a safety valve, I think we all felt, because you never knew what type of people the president would nominate.
Okay, we have time for a few more questions. Mr. Chisholm.
Bart, are you surprised some almost 30 years out now, courts are still looking at the BJRA and what it meant?
I think that because so little was written into the original legislation, it probably shouldn't be surprising that the court was given the freedom to set its own rules, and so you can have debates about what those rules should look like and what power does the court have. And so in the Monk position, the Veterans Court staked out a position right at the outset in response to a petition for rulemaking that they didn't have class action authority, and it took that long to reach the Federal Circuit, and I'm sure there are other issues like that that may occur even this far out from the passage of the bill.
Judge Kramer.
Well, I wanted to first thank the panel for what they created or helped create. I know all of you, haven't seen some of you for a little bit, but I recognize you and I appreciate your efforts, and it was interesting. I came on as the second act, you guys were the first act, so it was interesting to hear a little bit more of what I had always heard by the grapevine. So I appreciate you being here. And I also appreciate the job security that you. I do have one question, and it's a very unfair one, and if you don't want to respond, I would understand, because you, other than Bart, I don't know that you all would have had the benefit of following this history after the creation, having gone in different directions. But I would ask, you think that now that we're past the 25-year mark and you have referenced certain items of curiosity, do you think this would be an appropriate time for some entity, whether it be a commission or whatever, to take a look at the state of judicial review as it exists today? With a view towards perhaps making recommendations about what might be improved or what might be changed.
Sounds like a great idea.
I second the motion.
My sense is that it'd certainly be worth doing. My guess is to do it in the first instance. The court would need to come forward with some sort of an outline of proposed issues to be discussed or whatever, and come to the authorizing committees. And it might start with something as simple as hearings before the two committees, and then it could go from there. But yeah, I think it would be to the court to sketch out, these are some issues of possible modification, and then present those formally, informally to the committees. That's how I would go with it.
Yeah, I don't think it'd be quite as controversial as revising sentencing guidelines or something like that. But I raise that because it's really hard to gauge how serious Congress is about veterans issues from my perspective today.
Well, and one other thing I want to pick up on, and this is we've made reference to it at various points. When you look back, it is moderately surprising that Veterans Affairs committees created a court. That's not usually who makes courts. And in fact, what happened in the Senate, we got through the first time without much interference from the Judiciary Committee. In the next Congress, the leadership in the Senate had switched, and Senator Thurmond was chairing the Judiciary Committee. And when the bill was introduced, it was initially referred to, my memory is it was either referred, in the Senate it's not jointly referred, it's referred to one and then to the other if and when reported. But in any event, Judiciary got involved. And Senator Thurmond wasn't particularly high on, and I remember going with his staffer and making a presentation to him suggesting that the Vets Committee really could look at this, and what he did was he kept it, let us work. He participated because he was on the Vets Committee too. And then once we got to a point, he ran it through his judiciary staff and then let it go. But where I'm going with all of that is, and I remember this was, I don't remember when this was, but it was probably sometime in the 90s. There was a reasonably serious suggestion, it didn't come from us, but we got involved, of transforming this court into a court of disability appeals and running all Social Security cases. I mean, obviously be a much larger court, but all Social Security and black lung and federal employee and on and on and on, all disability, to create a single specialized court with expertise in disability issues. And that was coming out of judiciary. I mean, that's how I first heard about it. I don't know. I think the administrative office of the courts brought it to judiciary because the district courts wanted out of Social Security. My memory is when I pulled back the weeds to figure out what the hell was going on. That was the driver. Yeah. But it was a serious discussion, and when they were talking about it, if they were going to go forward with it, they were going to yank anything to do with the court away from us, the Vets Committee, and bring it into judiciary. So all I'm saying is that as if the court comes forward, be careful to keep it in the right lane, so as to not wake any sleeping.
I think we have time for one more question.
Thank you.
Anyone? Okay, Mr. Block.
I'd like to follow up on your comment, Mr. Brew, the reference to Congressman Edwards and the judiciary commitment crossover, and then the position being taken. Was there a position of the Judiciary Committee vis-a-vis the role of the Federal Circuit in this? And was there a position taken by the Judiciary Committee that was important to this staying as a unitary court outside the district courts?
On our side, we had gotten judiciary's sign-off, and I think it was in that the second Congress, and so we never had to, we had a ticket that we brought back every time, and they would just let us go. I don't know what happened with you.
No, they didn't take a substantive position on that particular issue. There was concern about the 65-member court, and Don Edwards was very plain that he expected that would change if the Judiciary Committee let the bill go, which he understood, as Bill pointed out, if anything was going to happen, they couldn't sit on the bill. So that's essentially what they did, is they asked for a referral and then did hold hearings and did nothing with the bill in any substantive way.
And that was probably in large part, I don't know this, but probably in large part because Don Edwards was senior on the Judiciary Committee, so that he could say to his fellow committee members, I'm okay with this.
Yeah, now, again, this is a long time ago, but now I do recall getting some phone calls from members of the judiciary staff, but I just figured at the time they were curious about what we were going to do, because we didn't tell anybody what we were going to do until it was almost too late for them to do anything. So.
Well, I'd like to just wrap up with one question and observation. I noticed when I read both committee reports of the final reports that when the bill passed, that they articulated that the motivation behind enacting judicial review wasn't because Congress was dissatisfied with VA, but instead it was articulated more that it was about to ensure fairness, that other people have access to courts, veterans should have access to courts. However, it seems now there is a high level of dissatisfaction in Congress with VA and with veterans with VA. Do you think, one, that the court could be enacted today, and two, did the court play a role in increasing this dissatisfaction?
I would be hard-pressed to find any evidence that Congress has been following the activities of the court in an active fashion. So I don't think there's any reason to suspect that the level of dissatisfaction with the VA that you've heard about from the Congress in the last 10 years is because of the court. I think it's all politics, plain and simple.
And I don't disagree, but I would add the one caveat, and this is the one, if I had the Wayback Machine, the thing that I would try and do in the context, and frankly, we didn't do. And the irony, of course, is that the House bill did do it. I don't think that with the creation of the court, that the Board of Veterans Appeals, in its current, in everything it has to do, both its composition and what it does, should continue to exist. The Board of Veterans Appeals was created to be a pretend court. I mean, that was the notion. I think that a great deal of the present dissatisfaction that you're talking about is because of there are a lot of factors, I think, gazillion, but a lot has to do with the fact that it takes so long from the start to the finish. And I believe that a major part of that it takes so long is the board in its current, the way it functions with a de novo review. That doesn't make any sense. I mean, make me czar for a day and I fix everything. But one of the things that I would do after I put a much higher premium on the original decision makers making decisions that they would stand for and stand by and get rewarded for or whatnot, when it leaves whoever the decision maker is, when it leaves, I am prepared to stand behind it. This is a solid decision and it is the right decision. And then I would have some sort of an entity that would work to ratify that, and then it would come to the court. But there would not be a full further review with new evidence and a new hearing. All of that, the back and forth that goes on with the court sending it back and then the board sending it back, and I think that's the root of the dissatisfaction. And so in that sense, yes, but no, I think if we could do it again and change everything that leads up to the court.
Well, if you'd have just agreed to making the board as the court.
We could have had a 65 judge court. Yeah.
Bart, any last words?
Well, I agree with Bill in the end that the courts has had an impact in the length of time it takes because of remands, both by the BVA to comply with what the court's doing, the court's rulings. Unfortunately, after all these years, the pathway the court has led has not reached the regional office level. And so you see the hamster wheel in force mainly because the regional offices, despite after all these years, hasn't adjusted. And so that creates, I think, a major part of the dissatisfaction.
Well, please join me in thanking our wonderful panelists. It's been very interesting